I'm the General Counsel of Fidicuary Trust Company of New England. We are a non-depository trust company which was chartered in 2014, and we created the affiliate so we could bring some of the great laws, trust and tax laws that exist in New Hampshire to all of our clients, so to our current clients and to new clients. And one of the things that we've seen a lot of lately, and so I'm particularly excited about, are trust modifications and how to fix a trust that doesn't seem to be working anymore. Well, there's a lot going on with trusts. You may have heard of the Kraft case. Robert Kraft, the owner of the Patriots, had a big case recently, and I think that's brought some good press to trusts in Massachusetts. The Kraft case, which was big here in Massachusetts that I referenced, that was a case where Robert Kraft had established a trust, a long-term trust, for his family. He had established the trust himself, and so he was the donor, and he was still alive at the time that they wanted to fix it. And so what he wanted to do was, he felt that at the time that he brought it to the court's attention, his children, who were the primary beneficiaries of the trust, were mature enough to handle serving as a trustee of their own trusts. And so he basically wanted to modify the trust so that his children could come on as a trustee. And these trusts were Massachusetts trusts, and so they were unable to make this change under Massachusetts law. The tool that he wanted to use was something called decanting. And so with decanting is what it sort of might sound like to you with wine. You take the assets in one trust and you put them in another, and you usually do that to improve the administrative provisions of the trust. And so they wanted to do this so they could accomplish their family objectives. And in Massachusetts, there's no statute which says you can do this, so they had to bring it to the court's attention and file an action in the court requesting that this be done. So they were successful in Massachusetts, and the court said, okay, Robert Kraft is still alive. He filed an affidavit which said this was my intention. A very important tenet of trust law is to carry out the donor's intent. And so in this case, it was nice because he was still alive and he could say, yes, this was my intent. And so what happened was the court said, okay, because the donor says this is what he wanted to happen, we're going to carry it out. So in Massachusetts, we have this case, which stands for decanting in Massachusetts. But in New Hampshire, if you want to fix a trust, you can do this by statute. And you might ask, why would you do it by using a statute versus case law, which is what we have in Massachusetts? And in New Hampshire, you would probably prefer the statute. The statute lays out exactly what you can and can't do when you decant. So for example, you can't decant into a new trust that eliminates what we would call a vested interest of a beneficiary. So you can't just take out beneficiaries that are currently receiving income. So the rules are very reasonable. And because this is a legislative act, there's a statute involved. Usually, the legislature works out all the kinks before they set it into law. So where in New Hampshire you have this nice, clear proclamation of what you can and can't do, in Massachusetts you have this case, which is great and stands for something, but to be honest, practitioners aren't exactly sure and probably can't agree as to what it stands for. So what we do in New Hampshire through our New Hampshire affiliate is we allow our clients to take advantage of these New Hampshire laws because we serve as a corporate trustee, and therefore we have trusts that are administered in New Hampshire, so you can take advantage of such laws as the decanting statute. People today are really looking at what jurisdiction they should set up their trusts in. It's nothing new, but I think with all the modernization in many states, not just New Hampshire, of their trust laws, people, both clients and lawyers that are drafting for their clients, are looking at all the different jurisdictions and trying to decide what jurisdiction the trust should reside in, where the situs of the trust should be.